Before we begin, it's right to record that this is a historic occasion. It's the first time that the Supreme Court, or our predecessor, the Appellate Committee of the House of Lords, has sat outside London. We're delighted to be here, as it enables us to underline the role of the court in serving the people and communities of every part of the United Kingdom. We're very grateful to the Lord President, who will sit with us later in the week, and his colleagues, as well as to Edinburgh City Council and to Police Scotland, for all that they have done to accommodate our visit and make us feel welcome. We're very pleased to see those of you who have taken the time to come and watch us in the courtroom today. That reflects much of the point of our taking this initiative. Thank you all for participating in this historic occasion. Mr. Bovey.
In this matter, I appear with my learned junior, Mr. Byrne, and the learned Advocate General appears with his junior, Mr. Webster. I have provided 2 pages of propositions of my submissions, which are in with a red tab in the bundles to your lordship.
Oh yes, I see. Thank you. That's very helpful.
To your lordship's left.
Like this?
Yes, indeed.
Thank you.
And these will serve to some extent as headings for where we're going, I hope.
Yes, thank you very much. That's very helpful.
And the first proposition is that but for the intervention of the respondents' officials, the appellants would have married on the 17th of April 2014. The court will have read the SFI, particularly paragraphs 10 to 13 on pages MS 27 and 28, in which something of what happened is narrated, but yes. In short, the appellants presented themselves at Leith Registrar's office for a marriage scheduled for 2 o'clock that day, and they were met by immigration officers who sought to interview them, whereupon they were interviewed essentially until the office had closed, and then detained, and the same day decisions to remove each one of them also made. In respect of the first appellant, the detention form is at MS 105, the removal form is at MS 105 and 106, and the interview is at MS 362. In relation to to the second respondent, appellant rather, the detention is at MS 107, the removal at MS 108, and the interview at MS 371. Now, it is, however, not agreed by the parties that the marriage would have taken place but for the intervention of the respondents' officials, notwithstanding the fact that, as I say, they were interviewed until the office had closed and then detained and indeed taken to different detention places, first in Scotland and then in England. The key, or a key document which I would wish to take the court through is the letter of 11th of April 2014 from solicitors acting for the second respondent, and it is at page MS 343. And
thank you. Yes?
It's a letter to some extent that set the ball rolling, and the court will see firstly that the Agents Act for Mr. Malik, that they, second paragraph, they're instructed to make an application for recognition that he is exercising treaty rights and soon to be a family member of an EEA national, that the applicant has a marriage scheduled at the registry office on the 17th, and that he's an overstayer, but that since the overstay he's had no contact with immigration authorities, that the couple have been in a relationship since February 2013, and as a result of that relationship now plan to marry on the 17th of April. In anticipation of their marriage, they've been residing together since the 6th of April at an address in Edinburgh, and there's a copy of a receipt from the property management company which confirms that this is the case. The EEA national is a Lithuanian national who is a qualified person. By way of providing you with an outline of the case, we enclose copies of some of the evidence, and there are documents relating to the EEA national, the first appellant, a receipt from the property management company, and statements from people who know the parties, and a brief statement from them, which is the statement of 28th March 2014, which has been something of a focus of the case. Then there's an indication at the next paragraph, but one, that you may wish to interview our clients regarding the nature of the relationship, and of course that is understandable. Similarly, understandably, our clients would rather you interview them prior to their wedding rather than on the day of the wedding. And then there's a summary of the position and a statement below at the last paragraph on page MS 344 that it's a human rights allegation of family life, and a reference to Article 8 of the European Convention. And over the page at 345, as indicated, our clients are more than happy to be interviewed by yourselves, and we can provide their contact details to you to facilitate this. And it was, as we understand it, in response to that letter that the respondents' immigration officers were present at the Leith Registrar's office on the 17th, and chose to interview the parties not on the morning of their proposed marriage, nor indeed on the afternoon after they had married, but at the very time when they were scheduled to marry, and as I say, in a manner that took till after the...
Is there any evidence as to when this letter was received?
Yes, it was faxed that day, my lord, so it was received on the 11th.
117.
1317. So it's got that top left. So that's it was the Friday, yeah. And I think the 17th was the following Thursday. Now, I move to the second proposition, which is that spouses are family members for the purposes of the regulations and the directive. And under this heading, I will address the directive in general terms, and thereafter the relevant provisions of the regulations. In the case of METOC, which is number 10 in the bundle, and particularly at pages MS 560 and 564, it is stated by the Court of Justice.
Which paragraph?
The Paragraph 82, my Lord.
Thank you. Yep, thank you very much.
At page 564,
Yep.
the directive aims to facilitate the exercise of the primary and individual right to move and reside freely within the territory of member states that is conferred directly on Union citizens by the treaty. And at paragraph 59 on page MS 560, from line 3, as is apparent from recital 3 in the preamble to the directive, it aims in particular to strengthen the right of free movement and residence for all Union citizens, so that Union citizens cannot derive less rights from that directive than from the instruments of secondary legislation which it amends or repeals. Reverting to MS 564, we see in the paragraphs dealing with the second question, and particularly the second paragraph on page 565, having regard to the context and objectives of the directive, the provisions of that directive cannot be interpreted restrictively and must not in any event be deprived of their effectiveness. And that, although the print is defective, that is paragraph 84
Yes.
of the Court of Justice's decision.
Thank you.
And at page MS 865,
Yep.
In an annotation to one of the regulations,
Yes.
there is a quote from Lord Justice Pitchford in the case of De Brito, where he says, "I accept that a purpose of construction should be given to the directive and the regulations."
Thank you.
Turning then to the regulations themselves, which are at that very tab 25. The first one is at MS 861, which is which is Regulation 6. In these regulations, qualified person means a person who is an EEA national and in the United Kingdom as, for our purposes, be a worker.
Thank you.
And then at page 891, Regulation 14, a qualified person is entitled to reside in the United Kingdom for so long as he remains a qualified person. And then over at page 895, Regulation 15, the following persons shall acquire the right to reside in the United Kingdom permanently. A, an EEA national who has resided in the United Kingdom in accordance with these regulations for a continuous period of 5 years. Then at MS 915, Regulation 19.3 at the foot of page 915, subject to paragraphs 4 and 5, an EEA national who has entered the United Kingdom or the family member of such a national who has entered the United Kingdom may be removed if, and we see over the page C, the Secretary of State has decided that the person's removal is justified on grounds of abuse of rights in accordance with Regulation 21B2. And going to that regulation at page 931, we see Regulation 21B, and we see the abuse of right to reside includes C, entering, attempting to enter, or assisting another person to enter or attempt to enter a marriage or civil partnership of convenience, and Regulation paragraph 2. The Secretary of State may take an EEA decision on the grounds of abuse of rights where there are reasonable grounds to suspect the abuse of a right to reside and it is proportionate to do so. And 5, this regulation may not be invoked systematically. And 6, in this regulation, a right to reside means a right to reside under these regulations. And in relation to family members, at page 866, Regulation 7. 1, subject to paragraph 2, for the purposes of these regulations, the following persons shall be treated as family members of another person, A, his spouse or civil partner.
Yep.
And looking at page 849, regulation 2, which is definitions, and at a definition of spouse. Spouse does not include a party to a marriage of convenience. And at regulation 8.5, which is on page 872, a person satisfies the condition in this paragraph if the person is the partner of an EEA national other than a civil partner and can prove to the decision maker that he is in a durable relationship with the EEA national.
Yes.
And at regulation 17 on page MS.
Sorry, what was the previous one?
8.5.
8.5.
Thank you.
On page MS 911, regulation 17, regulation 17.1, Secretary of State must issue a residence card to a person who is not an EEA national and is the family member of a qualified person or of an EEA national with a permanent right of residence under regulation 15 on application and production of a valid passport and proof that the applicant is such a family member.
We're not, are we concerned, or are we concerned with Regulation 8? You took us to the definition of extended family members, but we're dealing here with, are we not, with a spouse?
Well,
or if the marriage has gone ahead.
The point I'm seeking to make is that an extended family member is in a less favourable position, and that on one view, as a result of the intervention of the immigration officers preventing the marriage, the best that this couple could be would be a durable partnership. And so my Lord is right that is not our case here today, and I don't think it's the case the respondents are making, but it is an important part of the context, because it appears that it either was the aim, or may have been the aim of stopping it, to put the parties, the appellants, into a less favourable category, namely the durable partnership.
Well, you don't have to go so far as to say it was the aim, it was the effect, certainly.
It certainly was indeed, my Lord. Arguably the effect, my position is that where they have stopped the marriage in these circumstances, they didn't succeed in achieving that effect, but nonetheless it is relevant for the court to have this by way of context. And moving on then down that page to regulation 17.4,
Yep.
Which page is it, please?
Sorry, we're still on 911, my lady.
No, I'd gone back to 8.5 to follow up my Lord's point.
It's 911.
Thank you.
We're still Secretary, reading regulation 17.4, the Secretary of State may issue a residence card to an extended family member not falling within regulation 7.3, and we don't do that, who is not an EEA national on application if the relevant EEA national in relation to the extended family member is a qualified person or an EEA national with a permanent right of residence under regulation 15, and in all circumstances it appears to the Secretary of State appropriate to issue the residence card. Where the Secretary of State receives an application under paragraph 4, he shall undertake an extensive examination of the personal circumstances of the applicant, and if he refuses the application, shall give reasons justifying the refusal unless this is contrary to the interests of national security. So the position of the extended family member, including a durable partner, is less favourable on the face of 17.4, and indeed those who have been refused residence cards have recently been held by the upper tribunal not to be entitled to a right of appeal.
Well, that's subject to a degree of scrutiny at the moment.
The Salah case.
Yeah.
Yes, well, the position currently, that's the current position. Moving on then from my second proposition to the third proposition, that the burden of proof of an abuse of rights by an EEA citizen lies on the state alleging it. We see that the basis for the decision in relation to the first appellant is not that she has presented a sham durable partnership, but that she has attempted to enter a marriage of convenience, and we see that particularly in the notice at page MS 104. And the situation in my submission is that the burden of proof is on the state, notwithstanding that the marriage has not taken place, because it is the rights of the EEA citizen and her abuse of them that is at issue. And that the principle is the same whether one has a sham relationship with a close or a distant relation.
Yes.
Now, in Papa Georgi, the upper tribunal said, and this is paragraph 39 at page 581, in summary, our understanding is that where the issue is raised in an appeal, the question for the judge will therefore be, in the light of the totality of the information before me, including the assessment of the claimant's answers and any information provided, am I satisfied that it is more probable than not that this is a marriage of convenience? And in the case of AGO, which is tab 30, in other words, in the other bundle, at page 1074, the Court of Appeal said at paragraph 14 that this formulation clearly places the burden of proof on the Secretary of State.
Thank you.
That's page 1074.
Yes. Yes.
Now, in contrast, the inner house in the present case at paragraph 20 on page MS 80, which of course is in the blue bundle.
So just give me that page number again, please.
MS 80, my lord.
80.
80.
Yeah, thank you.
And perhaps I should read the whole of paragraph 20, beginning at page MS 79. Although the appeal to this court complains of the first-tier tribunal having misdirected itself on both onus and standard of proof, it is of note that these were not grounds raised with the upper tribunal. There, the point being advanced was that the FTT had failed to abide by the guidance in Papa Georgi to look at the totality of the information. Papa Georgi involved an application to enter the European Union on the basis of marriage to an EU national. A genuine marriage certificate existed. It is not surprising, therefore, that the UT held that this raised an evidential burden upon the state to prove its allegation that the marriage was a sham. However, as has often been said, once the evidence has been heard, questions of onus usually cease to be important. The view of the UT in Papa Georgi at paragraph 39, that the question in the tribunal context was whether it was more probable than not that the marriage is one of convenience in light of the totality of the information, accords with that dictum.
Well, you might want to read the first sentence of paragraph 21.
Indeed, there is no error of law in stating a general proposition that in immigration appeals the legal burden is on the appellant. The evidential onus may fluctuate.
Well, I think that's the first question,
Yes.
the first sentence in paragraph 21.
Yes.
And presumably you say that that cannot be right.
Well, you could be saying it cannot be right. it is right, but it doesn't apply in this case.
It cannot be right if it's simply left uncorrected,
Yes.
if it's not qualified. That's exactly so. As a general proposition, it is often the case that the burden, it is naturally the case that the appeal, the burden is on the appellant, but it fails to recognise that in the current case, the respondent bore the burden of showing that the marriage was abusive, and in those circumstances there was then a misdirection.
But it's expressed as a general proposition.
Indeed. It expresses a proposition that applies to these circumstances, and as such, as my Lord suggests, is completely wrong. I will also point the court in the direction of what the Court of Session said at page MS 85 when it refused permission to appeal to this court, really for completeness rather than because it helps in my submission, but I think it should do that. At page MS 85, a decision of the First Division refusing permission to appeal to this court, paragraph 4, the present application involves first a contention that the court erred in distinguishing between a situation where there was an extant marriage certificate and one where the marriage had not yet taken place. That was not the point of distinction which was being made. Rather, it was one between a situation where there was a genuine marriage certificate and one where there was not.
The first sentence in paragraph 3 is perhaps relevant.
The
Court determined that.
The court determined that as the... sorry, did my Lord say the third?
First sentence of paragraph 3.
The court determined that as the first tier tribunal had said, the initial onus in the appeal was on an appellant. The standard of proof was the balance of probabilities. The first tier tribunal had identified a number of factors pointing to the marriage being a sham. Although the first tier tribunal had not referred to the interviews in any meaningful fashion, when the circumstances were examined, no material unfairness could be seen to have occurred. And at paragraph 5, the second point was that the court had erred in distinguishing between the two applicants. However, that distinction in fact existed. One had a right of residence, thus throwing the onus on the state to justify the interference with that right, and the other did not. My submission, none of that really assists in demonstrating that the court has taken a correct approach to the question of onus.
Well, I mean, do you not go further and say that it is plainly not correct to say, as the court said here, that the initial onus in the appeal was on the appellant?
That's correct. Obviously, because, well, you have to show that you are, you have to produce certain documents to get in the door, which are to show that you are a spouse. Now, one of our, and then...
Do you accept that's correct?
One of the difficulties is, in this case, is that because it was stopped, the appellants here didn't have the spouse, didn't have the marriage certificate. But I don't accept that the way in which the first-tier tribunal put it was correct, because there was no recognition of where of the obligation to show that the marriage or proposed marriage was a sham rested upon the respondent.
Well, maybe one has to be attentive to distinctions between the two appellants, but so far as Ms. Sadovska is concerned, the allegation is that she has abused her right of residence and therefore is liable to removal under the regulations.
Yes.
Well, one might have thought that
Indeed.
if prima facie she has a right of permanent residence because she's been here as a worker for
Yes.
5 years.
Yes.
And she's alleged to have abused
Yes.
her right of residence, entitling the state to remove her. One might have thought the onus was on the state to establish the abuse of the right.
Because she doesn't have to show anything to do with being married. Only Mr. Malik has to show anything to do with being married because it's an obligation on the state to show the fraud rather than anything more. I'm obliged to my lord.
But if but then one also has to analyse the situation of Mr. Malik.
Yes.
And he's not in the same position as she is.
No. Though it is certainly a very curious position where two people get married for the outcome of the court's inquiry to be that if it were to be that one of them was guilty of being in a sham marriage and the other one wasn't, it is of course possible for one party to have different motives from another party, but there was no question of that, and there will be generally no question in a marriage, and so the issue and the outcome, the prospect of the outcome being different in relation to two parties to this sort of question in my submission is one that is counterintuitive to say no more.
I wonder, does it help to look at it this way? If one asks, what was the issue the FTT had to decide in relation to Ms. Sadovska, then it might be suggested the issue was whether she had abused her right of residence within the meaning of the relevant regulation. Okay. Now, what's the issue that has to be decided so far as Mr. Malik is concerned? If one leaves the EU aspect out of account for a moment, one might have thought that he would be, in principle, liable to removal as an overstayer. He might rely on a relationship with Ms. Sadovska for the purposes of Article 8, and the issue would then be, would his removal be a violation of his convention right? But I'm wondering, does the EU law aspect alter that so that the issue becomes something different?
It does, my lord, because the EU law gives him, if he is party to, if he is a spouse, gives him.
But he's not a spouse.
Rights. If he and the issue of whether a different approach should be taken because of the wrongful prevention of the marriage, which I'm now ready to come to, is at large, is the one that I'm putting before the court. If he were a spouse, then he has rights under the convention to enter and remain in the under the European law to remain in the United Kingdom. Now, the fourth proposition is that the first tier tribunal erred in law in not placing the onus of showing that the proposed marriage was a sham on the respondent. And under that heading, I address three matters. Firstly, a general proposition that he who alleges must substantiate. Secondly, the proposition that the marriage was stopped in a manner contrary to Article 12 of the European Convention on Human Rights. And thirdly, that the first tier tribunal fails to acknowledge periods, albeit brief ones, of cohabitation. The proposition that he who alleges must substantiate is found, and I don't know that your Lordship need look at it just now, but at paragraph 36 in Papa Georgie at page MS 581. The First Tier Tribunal failed to acknowledge this principle, in fact directed himself in the opposite direction, as we have seen, and also applied his own misdirection in considering this case. And at paragraph 18 of my written case, I have set out a number of occasions on which the First Tier Tribunal expressed himself in a way that suggested that the onus was, as he had indicated, he would apply, that the onus was on the appellants. My submission, reading the First Tier Tribunal decision, and particularly pages 100, MS 100 and 101, the First Tier Tribunal misdirected itself and proceeded on the burden, and proceeded on the footing that the appellants had failed to establish the genuineness of their marriage, rather than that the respondent had established that it was a sham. Now, in relation to the manner in which the wedding was stopped, the immigration officers neither had nor used any express power to achieve this. And we see the powers they did use, or the circumstances in which they stopped, at paragraphs 37 to 39 of my written case at page MS 42. And by and at paragraph 44, I've set out something of the circumstances, which is that the appellants felt they had to agree to be interviewed, and that it only became evident at the end of the interview that when they weren't satisfied with their answers, that they would not be able to marry that day. And in the context of this proposition, marriage is, in my submission, a strong right, subject only to national laws governing its exercise. And we see that stated by Lord Bingham in the case of Bayai at tab 18, paragraph 13 on page MS 706. At page MS 706, between F and G, and we see at page 716, Lady Hale's observations in relation to Article 12 at page 716, D to E. In paragraph 46, Article 12 does also envisage national laws governing the capacity to marry, but these must obviously be non-discriminatory and consistent with fundamental principles of dignity, equality and freedom which underlie the whole convention. And at paragraph 20 on page 709, Lord Bingham recognised that national law may properly authorize a national authority to delay a proposed marriage between a citizen and a third party.
Yep.
But of course, one would need a legal basis upon which to interfere with Article 12 rights, which we would expect to find in a law allowing for that to be done, and the authority for that is in the case of O'Donoghue, which is a European Court of Human Rights case, and the page citation there is MS 735. It's tab 19, it's the next case, at page 735, paragraphs 83 and 84. And
Mr. Bailey, can I just
Milord.
can I just return to the point I raised earlier? I'm just
Yes.
trying to be clear in my mind as to what the issues were here. The first appellant was served, Ms. Sadovska, was served with a notice of removal on the basis that on the ground that she was in breach of Regulation 19.3a, that she had breached, that she had abused her right of residence. So I can understand your submission that in determining that issue, the onus would be on the Home Secretary to establish that she had indeed abused that right.
Yes.
Now, so far as Mr. Malik is concerned, the decision in his case was based simply on his being an overstayer. And when one looks at the FTT decision, it appears that he was resisting removal as an overstayer on two grounds. One being that he had a family life in the UK, and the Home Secretary's decision was a disproportionate breach of his right to respect for his family life. So that's a straightforward Article 8 argument,
Yes.
where one would, at first sight, one might think the
Yes.
onus was on him to establish that he had a family life and
Yes.
that it was of sufficient strength to render the removal disproportionate. And his second ground of appeal was that he was a party to a durable relationship with an EEA national exercising treaty rights of movement.
Yes.
So he's relying there on the regulations implementing the EU directive. Again, one might think that it would be for him to show that he was indeed a party to a durable relationship with Ms. Sadovska and therefore qualified under the regulations.
Yes.
So it may be the issue of onus might be decided differently in relation to the two
Yes.
appellants.
The points that my Lord makes are, I think, an indication of the difficulty in which the respondent had put Mr. Malik, because as your Lordship focuses on him, by stopping the marriage, which on our account was a perfectly good marriage, which would have given him an entitlement to marry. Now, the presentation before the tribunal, which your Lordship sets, is, as I understand it, an attempt to remedy that situation by trying to fit in with the nearest part of the law that is available to him where that has occurred. And I can quite see the point implicit in what your Lordship asks, that it may not have succeeded. But on the other hand, your lordship will see that it was an attempt to deal with these issues and with the issues that I am dealing with now, and that there would be an issue under Article 12 and indeed Article 8 if an arbitrary interference with the right to marry were to avail the state in the way in which it would if the respondent were to succeed in defeating a valid marriage. So while I do see the points that your lordship makes, they don't, in my submission, address the fundamentals that were properly before this first-tier judge because of the troubling way in which the situation came about as to firstly the appellant not being married, and secondly the issue then as to whether the marriage they had tried to enter into was a sham or not. I was referring to the I think to paragraph 83 on page MS 735, and about the middle of paragraph 83, in the context of immigration laws and for justified reasons, the state may be entitled to prevent marriages of convenience entered solely for securing an immigration advantage. However, the relevant laws, which must also meet the standards of accessibility and clarity required by the Convention, may not otherwise deprive a person or a category of persons full capacity of the right to marry with the partners of their choice. And the point I'm taking from paragraph 83 of O'Donoghue is that the interference with marriage rights must meet the standards of accessibility and clarity as a law, and that wasn't here. They simply used their powers to interview and then their powers to detain, and there was no power used or in focus to prevent or delay a marriage. And the point that I make is that they could have interviewed, for example, on the morning of the wedding. They could have interviewed after the wedding, but they chose to exercise powers which the whole immigration officers undoubtedly have to interview and to detain. They chose to exercise those powers at the very time of the wedding and until the registrar's office had closed.
Yes.
Now, I have also referred to the case of Allen, which says in relation to Article 8 that the lack of legal structure meant that an interference with Article 12 rights was, so Article 8 rights in that case, was not in accordance with the law and therefore in violation of the Convention. And that was a case in which there was surveillance of an accused person in a criminal case. I remind the Court also that, as Lady Hale observed at paragraph 36 in Bailly, it was not in dispute in that case that the government would be free to deny any immigration advantage to a party to a sham marriage, and that is Lady Hale at paragraph 36 on page MS 713. Now, although the respondent in her case has made something of the fact that the letter from the agents was only 4 working days before the day of the wedding. It was Friday the 11th of April, and it was faxed, and the wedding was Thursday the 17th of April, the letter permitted the immigration officers to be there at the time of the wedding, and it is, in my submission, difficult to believe that they couldn't have been there at a different time or been at the flat which the appellants were sharing at a different time, and that indeed would have been, in my submission, a more useful exercise, because they'd have been able to see the accommodation which they claimed to be cohabiting in. But the wedding was would only be a few minutes in a registrar's office, and in my submission there was no reason why the interview could not take place after the after the wedding. Now, there are indicative criteria from the Commission's guidance on this matter, which are annexed to the Papageorgi case in tab 11, and it is perhaps worth looking at them, pages MS 583 to 584. Yes. And your Lordships will see on page 584 there are
Yep.
7 bullet points on that page of points indicating suggestive criteria, suggesting the possible intention to abuse the rights. And on pages 460 to, page 583, 584, there are 5 points suggesting that it's unlikely to be abuse of community rights. And put shortly, my submission is that actually none of these 12 indicative points is satisfied. And of course, the key ones are the 7 pointers towards an intention to enter a sham marriage. None of them was satisfied before the interview, the second one could have been satisfied after the interview, and in fact it wasn't, because it says a couple are inconsistent about their respective personal details about the circumstances of their first meeting, or about other important personal information concerning them. And in fact, they weren't inconsistent on any of these points, even after the interview. So there wasn't, at the point of interview, any support in the case law, because that's part of the case law through the Papageorgi case, to support the interview, still less to support the interruption or of the wedding. There also was, as we see at page MS 90 in the submissions made to the upper tribunal, at paragraph 9, there was reference to periods of cohabitation.
Yep.
Now, the definition of marriage in Papageorgi is, and it's quoted at paragraph 12a of the First Tier Tribunal on page MS 98, is a marriage contracted for the sole or decisive purpose of gaining admission to the host state, to which it's added, durable marriage with children and cohabitation is quite inconsistent with such a definition. And it is, in my submission, quite clear from both limbs of that cohabitation is a significant element, and that for obvious reasons. And the upper tribunal heard submissions which I have flagged up to you at paragraph 9 on page MS 90, that they had cohabited between the 6th and the 17th of April, and then from the 16th of June to the 4th of August, which was the date of the first-tier hearing and continuing as it was put. And yet, the first-tier tribunal, in finding that it was a sham marriage, paid no attention to these periods of cohabitation. It appears that the tribunal looked at what they said in light of what, with a view to discounting what they had done, rather than to shedding light on what they had done.
Yep.
Now, then, turning to my fifth proposition, which is that the interviews were unfair. I would address this under 3 chapters. Firstly, the importance of fairness in the context of Article 35 and Regulation 21B. Secondly, the nature of the unfairness. And thirdly, the fact that the first-tier tribunal failed to address fairness or make any submissions about the evidence and the submissions failed to make any findings about the evidence and the submissions it had heard. And as I have indicated a moment ago, the criteria set out by the Commission guidance were not met, and we see that the decision to interview the appellants was prompted only by the fact that they proposed to marry. At paragraph 12N on page MS 100,
Yep. Yes.
the first-tier tribunal says, second appellant answers similar questions when interviewed, providing differing detail to the detail provided by the first appellant at interview. I therefore find the contents of the interviews and the performance of both appellants at interview were sufficient to raise suspicion in the minds of the respondent. Now, in my submission, the circumstances should have been that there was suspicion which before the interview took place, rather than having suspicion afterwards. And in relation to paragraph 35, Article 35, we see that the procedural safeguards provided in relation to Article 35 are intended to ensure a high level of protection of the rights of union citizens and their families in the event of their being refused leave to reside in another member state. And that is found in the case of McCarthy in the European Court of Justice, which is tab 13, paragraph 50 at page MS 640. And in considering what the high standards of fairness require, I invite the court to have regard to the case of Allen. Now, that's a criminal case on entrapment, and obviously I'm aware of the limitations of the parallel that I can draw, but at paragraph 43 on page 817, they do deal with the question of admissions made to a cellmate put up by the prosecutors to obtain such admissions, and they address whether the admissions were made voluntarily, without entrapment, without inducement. And in my submission, the circumstances of the present interviews were unfair, firstly because of the circumstances of being interrupted at the wedding and interviewed by officials in uniform separately, and we see something of that in the statement that that Ms. Sadovska made to the upper tribunal at paragraphs 9 and 10 on page MS 263, where she says essentially she was terrified, the second aspect of unfairness, other than the circumstances of the interview, was that they held out the prospect of being allowed to marry that day, which created a pressure to forego safeguards. Neither of these disadvantages was inherent in the offer to be interviewed on the 11th of April. The upper tribunal suggested that because that letter didn't mention the need for interpreters, that somehow that was consenting to being interviewed without interpreters. But in my submission, it was an offer to make arrangements for an interview before the day. And what happened instead was that there was an interview on the day at the time of the wedding, where there pressure to forego safeguards was created by the circumstances and the prospect of being allowed to marry. If the court has regard to the interview at page 363, Ms. Sadovska's interview, the court will see frequently that she could not remember, looking at 363,
Yes.
she was wrong on her partner's date of birth, at least at first. She couldn't remember two different matters further down the page, and that reading through the interview, there were a large number of occasions on which she simply could not remember, and that is inconsistent. That, in my submission, is consistent with her evidence that she was, on that occasion, terrified. At page MS 368, in line 2, the questioner says, "You cannot tell me anything about your relationship, how it developed, who your witnesses are, his family names. Are you being paid to marry Salim today?" She comments very much on the gaps in what this woman is being said. But
is this designed to establish the unfairness of the interview or the lack of reliability of the responses?
It is designed to show that there were matters within the interview that support the proposition that it was unfair and which the tribunal should have had regard to. There were submissions made to the tribunal, the first tier tribunal, and they weren't responded.
But that's a different point. But taking us through line by line of this interview, it doesn't seem to me that it's directly pertinent to the question of whether the interview was conducted fairly.
It doesn't establish anything more than I've said, and I'll move on, my lord. The other matter that I would suggest might be in play here is that where the immigration officers have intervened so as to prevent the marriage and kept the proposed parties to that marriage until the opportunity to marry that day has been lost, it may be that it was in their minds that if they found that in fact everything was okay and the marriage was proceeding in good faith, there might be trouble, there might be complaints at that sort of behaviour. And so it might be that the issue, that the conduct creates a pressure on the interviewers to reach an adverse decision. As I said, the respondent submissions were made to the tribunal in relation to the fairness but not dealt with. Now, the respondent has put up the Iran case in relation to a decision-making by immigration judges, but in my submission, the issue of whether of what the appellants said at interview is self-evidently a crucial evidence, and so failure to deal with the fairness in which this was achieved was not in any way peripheral, to use the words from Iran at paragraph 16. Citation for the Iran citations is tab 37, paragraphs 13 and 16, page MS 1288.
Thank you. Yep.
Now, in relation to my sixth proposition, I say that taken with the other errors on the part of the first-tier tribunal, it cannot be said that the errors as to onus and the interviews made no difference. And I address this proposition firstly as to the correct approach in law, secondly as to the significance of the burden of proof, thirdly as to the first-tier tribunal decision, and fourthly as to the upper tribunal and the inner house. And in relation to the makes no difference, I would respectfully adopt the approach of the English High Court in the case of Nash, which is tab 22, where the judge said that the question was whether there was a risk that the procedure resulted in injustice or unfairness, and that the made no difference argument, and this is paragraphs 47 and 50, the made no difference argument was only for the very plainest cases. And that's page MS
801. Yep.
801.
Yep, thank you.
The guidance annexed to Papa Georgi says that members must build a convincing case. And my submission is that the circumstances were not, as the respondent says, such as could be said that the relevant facts had been established and that the misdirection on onus was unimportant.
Yep.
Contrary to the Advocate General's approach, there are in fact no facts found such as to make the onus irrelevant. It is an appraisal by this first-tier judge of the whole circumstances, and therefore the concept on which the respondent's argument is based is inapt for the present case. Looking to the cases on which the respondent relies to show that the burden of proof is of no matter, it starts with the case of Sanderson, and it's tab 14, a decision
Would it be right to say that the question of where the onus lies matters depends really on the facts of the particular case? I mean, in some cases it may be that a court misdirects itself, but when you look at its reasons for not believing somebody or finding in favour of somebody, that is, doesn't really, it obviously would have done it whichever way the onus had lain. In other cases it really makes a difference. Isn't it a fact-sensitive investigation?
It is, in my submission, it is useful to know that the judge is applying the right test once he has done the sort of appraisal that my Lord refers to. And where he has started off with the wrong self-direction, if he never reverts to say something that flags up that he's applied the right test, then firstly, the usual approach which my Lord adverts to can't be said to apply, because the judge has set himself down the wrong route, and it's not as if he just started off neutral and failed to address. Certainly, a judge in a criminal case who said, "Whom do I believe?" would be misdirecting himself.
Well, yes, I think criminal cases are different, because in this case, is it not right that you're concerned with the balance of probabilities?
Indeed, yes.
So in the end, it's a question, in many cases, it might be a question of who do I believe?
Well, in the...
it all depends on the particular facts of the case, that's all I'm putting.
In the Sanderson case and in the B case, which the balance of probabilities wasn't just that. In my submission, it was seen, and now looking at Lady Hale's judgment in B, where it was presented by her as a threshold and a safeguard. So it isn't just, and the Karana Karan approach, again, a lot of these cases, they say, well, we'll look at all the evidence, but then they go back to what Lord Justice Sedley called the probabilistic touchstone, did he call it? So I don't accept, in fact, in general, but particularly where the judge has set off down the wrong route, that if he doesn't correct himself and set himself down the right route, then this point isn't very important. The other thing is, of course, if this only matters if he hasn't made the mistakes. If he's made the mistakes, then if he'd been right on a number of points, the issue of onus might have reduced the certainty that he seems to feel in some respects, so that the misdirection, the approach that he takes on the issues being very clear, if in fact one takes into account, to take example, one of the things that he uses against this couple are that Miss Sadovska's mother had not attended, although she lived in Edinburgh, and also that Mr. Malik thought that she lived in Lithuania, and therefore the implication is he didn't know her very well. Now, in fact, it was the judge who was mistaken, because Miss Sadovska's mother did live in Lithuania, and therefore the explanation as to why she didn't marry, she didn't attend the wedding, was completely in place. And Mr. Malik's supposed ignorance of the family of the first appellant was misplaced. Now, if we work that in, and there are other concerns that I have, if we work that in, then we see that if the judge had not been mistaken on that point, who knows where a correct approach on onus might have taken him. So that's why I'm, in my submission, the certainty of the judge on this matter doesn't really assist his decision, because of a number of dubious approaches to the issues. They are the unfairness of the interview. Secondly, the mistake as to where mother was. Thirdly, the letter of the 28th of March. Fourthly, the letters of support. And fifthly, his general approach to marriage, if I can call it that. Now, I've dealt with the marriage, the mother point, I won't deal with that. The interviews, again, I've dealt with at some length, but what I will say is that there are, in fact, very few inconsistencies between what they say. There's a table of consistencies which I'll draw the court's attention to before I finish. Now, in relation to my case at at page MS 38, I wonder if the court could have MS 38 in front of it.
Yes.
Now, at paragraph 22 on page 38, I say that the contradiction between the statement and the notice to marry was not put to the appellants at the FTT hearing. Now, I regret to say that that is wrong, and if your court would take the word "not" out of that sentence, then I can only...
I had already done so, Mr.
I can,
It's right in every way but one word.
I can only apologise to the court for this mistake.
Okay,
and in relation to the next sentence, if it could read, they gave the following explanation for the contradiction, because in fact, although that explanation only came to me at consultation in April, the notes that I have subsequently received essentially are supportive of that explanation. Which
so they gave the first, up to the semicolon, 23 reads, they gave the following explanation for the contradiction.
Yes.
Thank you.
Yes, and again I apologise for this mistake.
Don't worry.
So we have, it takes me straight into that issue, as the court appreciates this letter on the 28th talking about the relationship, says we've taken no steps to marry, although on the 25th they had done so, and the explanation is that they got Mr. Qureshi, who had good English, to type up their statement, and of course, because they don't have good English, they didn't see the error when it came before them. The issue that in my submission it raises is that it is used by the first-tier judge to reject entirely the evidence of the appellants. And yet, in my submission, bearing in mind that this letter of the 28th, with this a rather strange error, is my submission, not on the face of it in any way sinister. It doesn't show any lack of knowledge of each other, and it doesn't show any attempt to mislead any other person in any material fashion. And so the circumstances in which it comes to be that the whole of the credibility of these people is destroyed by it, in my submission, is far from clear, against the background, for example, of the dozens of photographs of the couple out and about at various events together.
Surely the simple point about this letter is that if it was part of a stratagem to deceive the authorities, it would have been couched in rather better terms than it has been. It was a pretty poor strategy.
It's impossible in my submission to see what deception is being attempted here, and the judge doesn't record anything as to how this came about, or analyse anything about why it is so damaging to these people's credibility. The curious thing, finally, is that Mr. Qureshi's letter in support of these people is dated the 21st. And so he did date his own letter the 21st, and he dated their letter the 28th. But we're now at a stage where we have no further material available to us, essentially, some years on.
I just understand what your legal proposition is. In the FDT decision, the judge identifies the inconsistency between booking the registry office on the 25th of March and signing a document on dated the 28th saying that they've not yet formalised any plans to marry.
Yes.
And he says, on the basis of that alone, he says, I therefore find I can place no reliance on the appellant's evidence.
Yes.
Now, our jurisdiction is an appeal on the ground of on error of law. Are you inviting us to find that this was an unreasonable process of
I'm presenting this in the context of the essential proposition that it can't be said that the error on onus and the unfairness of the interview made no difference to this judge's determination, because there are a number of problematic aspects of this judge's determination. So your lordships are not being asked to rule, as it were, on this, but just to be aware of the issues that are with this determination. And the aspect that every potentially favourable matter, such as letters of support, were rejected, even though one of them corroborates the circumstances of the meeting, which is a key point, simply because the friends didn't come from Edinburgh to Glasgow. That isn't a basis for rejecting evidence where, in a tribunal where everything is admissible and the only issue is the weight to be given to it. There are no admissibility. Finally, in relation to the problems which the determination has, my submission is that much of what the judge says at page 100 and 101 tells us more about his idea of a wedding than necessarily any objective view.
Yep.
he particularly picks on the 11th hour consultation of solicitors and the lack of planning. Now, if we look at the interviews, we see that both these people were immigrants employed as cleaners, and that they spent £150 on the wedding. So the dynamic of this wedding is perhaps not what an immigration judge has in mind, but in my submission he is in danger of falling foul of Lord Bingham's warning about substituting his own views as to what a reasonable person would have done in the context of different nationalities and cultures. Turning to the upper tribunal, which is at page 80, MS 88.
Yep.
At paragraph 20, the upper tribunal rewrites the first tier tribunal's decision by taking out the headings to paragraphs 11 and 12, in my submission quite an illegitimate fashion. At paragraph 20, at page MS 93, it finds the overall analysis in line with Papa Georgie, which in my submission it cannot be said to be, the approach to the unfairness of the interviews on the part of the upper tribunal is, in my submission, entirely superficial. At paragraph 17, it looks only to what more could have been said, doesn't look to the effect of the nerves on the first appellant's part, which she spoke to in the statement that I've referred to, with a view to, nor does it look to the context of the legitimacy of interviewing where there was no basis for suspicion and where there was an interference with the marriage rights. So in my submission, the upper tribunal has failed to put right in any respect the flaws in the first tier tribunal. It was agreed before the upper tribunal that if the finding was legally unsustainable, it should be remitted to the first tier tribunal, and that is the motion that I have been making once I have dealt with my last two propositions.
Right.
Now, the proposition 7 is that the first tier tribunal overlooked the issue of whether the first respondent had a right of permanent residence in terms of Article 28.2 and Regulation 15.1a, and I'll address the case law, the material on this issue before the first tier tribunal, and the result of the failure to address it.
Yeah.
In the case of Wambua, which is tab 46, Lord Brodie in her house said it wasn't enough for a permanent resident to have been here 5 years. Precise status is fact sensitive. Must, for example, have been here as a worker.
Which page is that?
That's page MS
Yep.
63.
No, Campus 63.
Sorry, my lord.
Starts at 1519.
It's tab 46.
It's tab 46, it's page 1519, yeah.
1519 is the beginning of
Yeah,
the case.
Well, if you haven't got the reference, don't let us know later. Thank you. Yep.
Yes.
Yep. You can let us know later. Yep.
We will do. Paragraph 10 is at MS 1525.
Thank you.
And it is that's the effect of it.
Thank you.
Is this, just looking at the form of this, is this one of these situations where a single judge can give a decision
Yes.
of a division?
It isn't open to any form of appeal, and therefore it carries very much the limitations that leave our permission determinations have, though that hasn't, I think, yet percolated through to Scotland, but nonetheless it does. the case of Ziolkowski and Chop, which is 41 and 42, referred to by the respondent, relate to the situation whereby citizens of the states joining the EU can use the time they spent in the EU before accession, and is a different situation. Right. The position here is that the evidence was that Miss Sadovska had been employed and was here as a worker, and in particular at page MS 358 is her registration scheme a documentation. Right. And this was before the first tier tribunal. Yeah. And it's dated 2007.
Sorry, what was the page?
358.
358 is her registration worker scheme at page there, and at page MS 259.
Yep. The statement. Yep.
Is her statement, which was before the tribunal.
Yep.
And at paragraph 2, she sets out an employment history from 3 months after her
yes.
arrival.
Yep.
And so there was no suggestion of claims on the social security system which would suggest periods of economic inactivity. And although therefore the matter was not pursued until now, nonetheless there was material before the first tier tribunal on which it could be found that she had been exercising her rights as a worker for 5 years and was entitled to permanent residence in terms of Regulation 15.1a. There was certainly no suggestion that she had any residence on any other legal basis, as some of the cases proceed to. And the security that Article 28 gives was not accorded to this appellant. And I then turn to Proposition 8,
yep.
And the risk that the decision to remove the first appellant was taken on a misapprehension of her status, in my submission, further undermines the decisions of the courts below. A new point can be taken on appeal where this is necessary to do justice to all the parties. And clearly, if it would have been open to the first tier tribunal on the material that I have pointed you to find that she was a worker with permanent right of residence, the respondent would have carried out by then all the preparation and fact-finding that she would be able to do. And in those circumstances, the concept that there is prejudice to the respondent, in my submission, is ill-founded. And so, in those circumstances where this enhanced protection is important to this appellant, and is one to which it appears she is clearly entitled, the fact that the point is being taken at this belated stage in my submission, it should not prevent this court from doing substantive justice. Right. In that regard, I would prefer the approach of the court in Miskovich to at tab 40, and in particular paragraphs 129 at page MS 1407. I think I should take take you to it because there is a contrary approach taken in the Wambua case, which the respondent is relying upon. And this is Lord Justice Moore-Bick at page MS 1407. And it, at paragraph 128, the judge quotes the section, which is the section that applies to us here as well.
Okay.
And it's a point of law arising from any decision. The important words are on any point of law arising from a decision made by the upper tribunal in subsection 1. Mr. Coppell submits for the Secretary of State that the only questions of law actually raised and argued before the tribunal and points of law that were so obviously relevant that they should have been considered by it of its own motion, that's Robinson obvious paragraphs, grounds, can be regarded as giving rise to questions of law for this purpose. On another view of the matter, however, the assertion that any principle of law on which the tribunal's decision depends has not been correctly decided can be regarded as giving rise to a point of law arising from its decision. And that is the basis on which Lord Justice Moore-Bick decides the case over on page 1408, paragraph 134.
Thank you.
In contrast, Lord Brodie in Wambua, which is tab 46 at page 1527, says, beginning at the, deals with paragraph 14, that the point under Article 24.3 was not before the upper tribunal was freely acknowledged by Mr. Mitchell. He considers then Robinson, and 3 lines before the foot of the page, this court only has jurisdiction in respect of a point of law arising from a decision made by the upper tribunal. Here the decision made by the upper tribunal was on the question raised in various articulations in the 4 grounds of appeal from the FTT and encapsulated in permission. As is acknowledged looking to line 5, the UT was not asked to have regard to Article 24 rights. And then a few lines below, the approach which ground 4 has now said the UT should have adopted radically different from that which was contended when the appeal was argued before the UT and by reference to the UT made its decision. Unsurprisingly, there's nothing in the UT's reasoning about 24.3. Accordingly, while the ground 4 point is no doubt a point of law, it is a point of law in the abstract. It does not arise from the particular decision of the UT which the applicant wishes to bring under appeal. The court therefore does not have jurisdiction in respect of an appeal presented under ground 4. So on that basis, no matter how good the point was, the Court of Session simply could not intervene, which in my submission would be a highly unfortunate circumstance. And so in my submission, while the court may not exercise its discretion in my favour, I certainly ask the court to find that it does have a discretion to entertain this matter. And in fact, I invite the court to find that it is a substantive matter in favour of this appellant. Yep. In these circumstances, I simply invite the court to allow the appeal. As I say, it was agreed before the upper tribunal to remit the matter to a first-tier tribunal differently constituted, and I see no reason not to adhere to that approach, albeit that there are other courts between us and the first-tier tribunal. And unless there's any other matter on which I can assist, I'm very grateful to the court.
Thank you very much indeed, Mr. Gravey. Thank you. Mr. Byrne.
My lady, my lords, I have nothing further to add.
Advocate General.
appear that my microphones are going to adhere to the instruction that has just been given to them. I don't know if you can hear me sufficiently well, and whether matters will be sufficiently recorded if I simply take my junior's one microphone.
We'll have to make do with the best we can unless one of your opponents is prepared to let you have one of his.
See how we get on.
I'm sure they haven't spiked them, so you'll be fine.
Something's happening.
It certainly looks as if that one's
This
working.
one, yes, one's
So
now
if you
come
put
on.
that in front of you, let's see how we go.
I oblige. My lords, my lady, I invite the court to refuse this appeal, and I begin by adopting the respondent's written case as presented to the court in its terms. It respectfully appears to me that the primary question is whether the first-tier tribunal was entitled to find as a fact that the first appellant was proposing to abuse her rights as an EU citizen in the United Kingdom by entering into what is termed a sham marriage, or a marriage of convenience. It is, of course, well established that EU member states can take action to prevent abuse of rights conferred on EU citizens. And in the immigration context, reference has already been made to the Citizens Directive at Article 35, which is at MS 428. And I don't go back to that at this stage unless your lordships wish me to do so. And of course, the provisions of that article are subject to procedural safeguards as provided for at Article 31 of the directive. Domestically, these matters are addressed by the Immigration EEA Regulations 2006 at Regulation 21B, paragraph C, and again reference has been made to that, and that is at MS 931.
Thank you.
The decision taken in respect of the first appellant, Ms. Sadovska, was just such a decision. And we can see that from the relevant notice, which is in appendix, or I should say MS 104, and is dated 17th April.
Yes.
And I wonder if we could just turn to that for a moment.
Yes.
And this, dated 17th April, is a notice to a person liable to removal pursuant to the 2006 immigration regulations. And it states, under reference to the first appellant, I've considered all the information available to me, and I'm satisfied that you are, and then B, by virtue of Regulation 19.3c and 24.2, a person in respect of whom removal directions may be given in accordance with Section 10 of the Immigration and Asylum Act 1999 as a person whose removal is justified on the grounds of abuse of rights in accordance with Regulation 21b2 of the 2006 regulations. And of course, as we know, pursuant to that notice being given, the first appellant was detained, although later released. And of course, had that notice been given not on the Thursday, but the Wednesday, or the Tuesday, or the Monday, the first appellant would have been detained pursuant to the enforcement provisions of the immigration regulations. And as a consequence of that, the marriage, which was set down for the 17th of April, would not have taken place on that date. But the immigration officials did not act to prohibit or prevent the marriage, as my learned friend seeks to assert both in his written case and his oral submissions. What the Home Office officials did was to identify an abuse of EU rights, giving rise to a need for enforcement and the consequence of detention. Of course, it was an incident of those events that the marriage itself did not take place, although it could have taken place at a later date. As far as we know, it never did. Now, of course, pursuant to Article 12 of the Convention, there is a right to marry. Again, your lordships have been taken to that. The relevant article is at MS 434. But the right under Article 12 does not preclude the ability of a state to respond to attempts to enter marriages of convenience for the purpose of securing an immigration advantage. And that is abundantly clear from the House of Lords decision in Regina, ex parte Bei, and also from the Strasbourg jurisprudence in the case of O'Donoghue and the United Kingdom. And again, reference was made to that. O'Donoghue's at MS 735, and Bay is at MS 709.
Yes.
And of course, I appreciate that Bay and O'Donoghue were challenges to what were then certificates of approval, which were a requirement at that time under the immigration regime before a marriage could take place in certain circumstances. And we've moved on from those circumstances. But the underlying point made, both by Strasbourg and by the House of Lords, is that there is a right to inquire into, to investigate a proposed marriage, and to effectively respond to a proposed marriage if it appears that it is in fact an abuse of the right of marriage for the purpose of securing some immigration advantage. So, consequent to that, any national authority may impose reasonable conditions, for example, on the right of a third country national to marry, in order to ascertain whether the proposed marriage is one of convenience. And again, that follows from the observations of Lord Bingham in Regina ex parte Bei at paragraph 22. And it would be rather odd to have a right to prevent a marriage of convenience, but no right to investigate whether it might be a marriage of convenience. And therefore, I certainly take issue with the suggestion made at paragraph 40 of the appellant's case, that's at MS 42, that somehow the officials, the immigration officials, did not have the right to investigate this matter.
Yep.
Sorry, I don't have MS numbers on that part of my...
It's 43.
I'm obliged. MS 42 and 43.
Yep.
As I say, I take issue with that. I also take issue with the proposition at paragraph 40 of the appellant's case that the respondents deprived the appellants of the right to marry. They did no such thing. It was an incident of the enforcement proceedings and the consequent detention that the marriage did not take place on the 17th of April. But again, it is quite wrong to characterize the actings of the respondents as prohibiting a marriage. It may
Paragraph 42 of the appellant's printed case doesn't suggest, does it, that the respondent did not have the right to investigate whether this was a sham marriage.
Well, with
Paragraph 40. Paragraph 40 it may be that you're referring to.
the state may only deprive an individual of his or her right to marry pursuant to Article 12 where the marriage is one of
Yes, I see.
convenience.
Yeah.
It may not do so in order to inquire whether it might be, as appears to be the case here.
Yes. So it's not paragraph 42, it's paragraph 40.
It's
Yes.
paragraph 40 at MS 42, my lord.
Yeah.
Sorry, I misunderstood
That's all right.
the
No.
Lord's reference. But they do actually say in terms.
Yes, I see that.
It may not do so. The number 22 appears in my print for some reason.
That's all right, don't worry.
So I take issue with both of those propositions. Now, investigatory action undertaken by the Secretary of State's officers on the day is then described at MS 43, paragraph 41 of the appellant's case, as arbitrary, disproportionate, and an abuse of power. And I assume, although my learned friend did not labour this in his oral submissions, that the appellants adhere to that proposition. It's not entirely clear whether that reference is to any action before the day of the proposed marriage on the 17th of April, or only to the actions of the immigration officials on the day itself. But that may be a distinction without a difference at the end of the day. But to the extent that it is intended to refer to actions at any time, or indeed on the day itself, it is quite clear that after notice of an intention to marry, which is what was given to the respondents, and in light of the Strasbourg and domestic jurisprudence, there is a right to carry out further investigation and inquiry as to the particular circumstances of the proposed marriage. But moreover, in the particular circumstances of this case, the appellant's agents, of course, invited such inquiry. And I refer back to the letter that was faxed on the afternoon of Friday, the 11th of April, 2014, to the Home Office.
Is there any evidence as to why an inquiry wasn't made before the 17th of April?
I don't think there's any direct evidence, my lord, but let's be clear. This letter was sent on the afternoon of Friday, the 11th of April, with respect to a proposed marriage that was going to take place on the 17th of April, leaving 3 working days intervening between the receipt of the notice and the day when the proposed marriage was to take place. But as I pointed out earlier, my lord, even if the appropriate investigation and inquiry had been carried out on the Monday, Tuesday, or Wednesday, the result would have been the same if the factual matrix was the same, namely that there would have been steps for enforcement, consequent detention, and therefore no marriage on that date anyway.
Yes,
so whether it was the 17th, the 16th, or the 15th, really, it makes no difference
No, my
whatsoever.
inquiry was really a prosaic one. Was there any evidence?
I don't understand that there was, my lord. But I would just refer back to the letter of 11th April for a moment at MS 343. And if your lordships could just go to the end of the letter, although, of course, I put the entire terms before the court. As indicated, our clients are more than happy to be interviewed by yourselves, and we can provide their contact details to you to facilitate this. So, our clients are more than happy to be interviewed, was the invitation. So it's not just a case that pursuant to the relevant jurisprudence in Strasbourg and domestically, that there is a right to carry out investigations and therefore to interview. There was a positive invitation that that should be done. And I would add, just in passing, no suggestion that any form of interpretation would be required for the purposes of such interview.
Does the evidence show whether this letter came completely out of the blue? Do we know what the origin of it is? And was there any communication between the parties before that?
I'm not aware of there having been any communication between the parties before the receipt of this letter, my lord. And certainly, I don't believe there was any evidence to suggest any prior communication between the parties on that point. Yeah. And indeed, just to emphasise that, the upper tribunal noted the appellants made much of offering to be interviewed in advance, but the notice period was very short, and the respondent does not have teams of officers standing idly by to respond to such requests. It was only to be expected under those circumstances that the interview came to be on the day of the proposed wedding.
What's the MS number for that?
That's
please?
MS 91, my lord.
Thank you.
So it would appear from that, my lord, that there was no prior notification of any kind. So, my lord, there is no question in my respectful submission of any arbitrary or disproportionate action or abuse of power, as is alleged by the appellants in their case. What was done in the fulfillment of a legitimate entitlement to investigate an investigation that was carried out within a very narrow time frame. Now, of course, the appellants make reference to the presentation of the officers, and my learned friend has alluded to that in his oral submissions to the court. And the allegation, which is made at paragraph 44 of their written case, that the first appellant was told that to have permission to marry, she needed to answer questions. Lord, we don't understand there to be any evidence to that effect. Certainly, it's not apparent that any such evidence was before the first-tier tribunal. The appellants themselves had invited interviews. The appellants were cautioned. They were happy to be interviewed in English. The questioning was not of a technical nature. And indeed, no material inaccuracy has been identified in the answers that were recorded, not even today. And in these circumstances, we respectfully submit that the inner house was correct at paragraph 23 of their opinion, MS 81, with respect to the matter of the interviews. The appellants don't begin to make out a case of abuse.
Yep.
Now, my lords, turning to the decision itself, we would submit that the decision of the first-tier tribunal is not flawed by error of law, either one, in considering the interviews, or two, by virtue of any misdirection with regard to the matter of onus of proof. Before the first-tier tribunal, there was an issue of fact to be resolved, namely whether the parties were attempting to enter into a marriage of convenience, that being the basis for enforcement action against the first appellant. And in determining that issue of fact, the first-tier tribunal had regard to and weighed the evidence before it.
Well, the weighing of the evidence could be skewed by the articulation of a wrong test as to where the burden of proving their proposition lay. Do you accept that?
No, my lord. And
So it couldn't be skewed.
well,
Before they embark upon the fact-finding exercise, if a first-tier tribunal articulates a wrong test as to the burden of proof, you say that it's not possible that would skew consideration of the
Well,
matter.
anything is possible, my lord. I'm saying that that is not what occurred. First of all,
Well, I mean,
there was
saying that it's not what occurred
Well,
is a different answer.
well, with respect, my lord, if I could complete my answer, let us begin by observing that the first-tier tribunal did not err on the matter of onus of proof. When coming forward in this context, the initial onus would be on the first appellant to establish that she is an EU citizen.
I think if we're embarking on this rather important issue, would it be sensible to resume at 2 o'clock?
I'm sorry, my lord.
No,
I
no,
haven't
don't
noticed
apologise
time,
at all. It would, I think, be more sensible. So we'll adjourn now and we'll resume again at 2 o'clock.
but-
Thank you very much, Advocate General.